Have your firm at your fingertips, anytime, anywhere. With LawPay, you can track time at court, invoice from the airport, and get paid while you sleep. Plus, when you sign up by November 30th, you'll enjoy 12 months of no monthly fee. Learn more at lawpay.com/DCBar.
Welcome to Brief Encounters. Hi, everyone. I'm Elizabeth Selmo, and I'm a partner in the family law group of Feldsman Tucker Life for Fidel in Washington, D.C. I'm here today on behalf of the family law community of the D.C. Bar, and I'm excited to be joined by Darin Rumer. Darin is also a partner in the family law practice at a leading Washington, D.C. firm, Joseph Greenwald Laake. Darin counsels clients going through divorce and custody litigation and has more than 20 years of experience applying what he has seen in litigation to pursuing effective out-of-court resolutions. Today, we're going to have a brief conversation about some of the overarching principles that go into consideration for litigating family law cases, but also how to take what you learn from litigation and steer it towards out-of-court resolutions. While many divorces involve intense emotions, the vast majority of divorce and child custody matters settle out of court. However, there are a lot of lessons we can learn from those cases that do go to trial, which in turn can inform the way other cases can be settled in less contentious ways. In the end, family law clients are looking to end one chapter of their lives and move forward. So, Darin, let's talk about some of the common hangups and pitfalls of complex divorce and custody proceedings, and some of the ways that avoiding those issues can lead to more constructive resolutions. For starters, just for background for folks who maybe haven't done a lot of custody litigation, in broad terms, how do courts determine the best interests of the children?
So courts have to look at the best interests of the minor children, and that's kind of a broad term. Overall, there's a myriad of factors that the court looks at, but the primary factors are fitness of the parents, talking about their mental health, whether they're gainfully employed, are they stable, are they irresponsible, are there issues of drug or alcohol use and abuse, violence toward the other spouse, those types of things. But again, that's just a broad stroke toward what the fitness entails. It could be many different things affecting the fitness of the parent. The role of each parent in nurturing and raising the children. A lot of judges will look at the status quo, who's been doing what prior to filing the complaint for divorce or the complaint to establish custody. Who takes the child to the pediatrician, who takes them to and from school, who's responsible for arranging play dates, doctor's appointments, all those types of things the court can look at. The relationship of the children to each parent, the child's preference. And when children are older, the court can look at that in more detail. Obviously a 2, 3, 4, 5-year-old doesn't really have a preference of one parent or the other. And when they get older, if the court finds that they have considered judgment, in other words, judgment that they're not saying, hey, I like staying at mom's because she lets me stay up all night, or dad always feeds me pizza, but legitimate, reasonable basis for their preference, the court would consider that and can consider that. Then there's a whole nother long discussion of how does the court consider the child's preference with, best interest attorneys or therapists and whatnot. The court looks at the home, the school, the community, the availability of support systems for each parent, their friends in the community, whether they have other family members to help out, grandparents, aunts, uncles, that sort of thing. The lifestyle of each parent as a role model, their employment, the age and sex of the child. Again, I said preservation of the status quo, the willingness for them to share custody and time with the children with each other. Sometimes we find a lot of gatekeeping by one parent or the other where they're really not open to the other parent having time, and that's a consideration for the court. Any prior abandonment or surrender of the child. Sometimes you'll see a case where one parent left for quite a while. I had a hearing earlier this morning, and the mom left and went overseas for 18 months and is really having a hard time explaining it to the court why she just up and left 3 children and left them with dad. And that kind of dovetails into the desire to co-parent with the other parent, character and reputation of the parties. And so those are some of the broad areas, but within each of those, there can be a lot of different specifics that your family law attorney can delve into and point out to the court to have the court consider what's in the child's best interest.
Yeah, so a lot of the things that you mentioned really sounded complicated, and we know there can be a lot of nuance in how to present that information. So how does understanding all of that, the way that a court would look at child custody, How do you as a family law attorney use that perspective to help your client reach an agreement with the other parent, including even those where there's really high levels of conflict?
Well, firstly, a lot of times clients come in and they want to tell you everything about their relationship from, beginning to end. And what they may think is important might not be important. And there might be things that they overlook that, are critically important. As a family law practitioner, you use your experience and your background and having appeared before the courts and knowing what's important to a judge to hear or not hear, kind of hone the facts to the best interest in presenting a case. Then, in trying to settle a case, whether it be litigate and then try to negotiate or attending mediation, you have to put that in a format that the other side, the other attorney or a judge can understand and have the evidence prepared so that you can present it to the court or the mediator at that time.
For those cases that don't settle, that are resolved by the court, what are some of the long-term effects that you've seen of custody battles and acrimony between parents?
There are just really a lot of long-term effects. And there's been books written. I have a book here, The Unexpected Legacy of Divorce by Wallerstein Lewis and Blakesley. And it's, a thick treatise on, all the things that can go in and adversely affecting kids, coming out of divorce cases. There's trust issues, there's anxiety, depression, conduct disorders, et cetera. And so if you look at the long-term studies, where conflict between parents is resolved, it puts your children in a better position to be successful later in life. A lot of times you'll hear somebody say, well, you've got to co-parent with them, the next however many years until they're 18, whatever it might be, the next 10 years you need to co-parent with her, or you've got 5 more years with him. But that's not true. You're their parents for the rest of their life. And so there's going to be graduations from college, anniversaries, weddings, and you have to think of the long-term effects of your relationship and how that affects the kids. And, having practiced for longer, a lot of my clients, send cards, they send Christmas cards. I had a client send me a letter from a vacation she was taking and said, oh, this vacation wouldn't have been possible a year ago. But now that I'm, divorced and have freedom to travel with my children, here we are. I think they went to like Iceland or somewhere. And you can see the benefits of parents that prioritize the children and their needs versus, maybe seeking their pound of flesh or wanting to really retaliate against somebody who's not been the ideal spouse. And so prioritizing the children is something that I really do talk to my clients about. And it's not always, sharing equally. Sometimes you have to, really say, I think it's better if you were to have more time with the kids and dad have less time, or vice versa, whatever that might be. But we talk about the case specifics of the children, what the family dynamic looks like, and then how to best achieve that.
So that's great. And that's a great example of, a situation where the family didn't litigate, and a few years down the road when things have sort of settled, there's a lot more normalcy, consistency, and happiness for everybody involved. So for those clients who can recognize those benefits and do want that kind of an outcome, what are some of the alternative dispute resolution options that are available nowadays?
So when a client first comes in, we do go through, the family background, their history, the medical care, the school, et cetera. And including with that is like, what is your spouse's participation level and what is it that they're looking for? And of course, they know that so much better than I would because they're the person that has lived with this spouse for however many years. And we talk about their goals and the way to achieve that. And one of the ways to do that is to, sometimes send a settlement proposal in writing to another attorney like yourself, outlining, what it is my client's asking for and wants. And then sometimes we'll go back and forth, and one or the other of us will draft a separation agreement or a marital separation agreement resolving the case. Sometimes if they need assistance with that, we can offer mediation. And a lot of times we know experienced mediators, either senior attorneys who, are trained in mediation and can help and assist with that, or oftentimes using a retired judge to come in and sit with counsel for both parties, the parties, and mediate. And then there's collaborative law as well, where everybody chooses not to litigate and they go into the collaborative process trying to reach a common goal. Or oftentimes things lead to litigation and you're in litigation. And during the course of the litigation, there comes a point that you're in a position to negotiate a settlement And we can even initiate mediation in the middle of a litigation. Of course, DC requires mediation in the custody cases, so that's always helpful as well.
Let's maybe switch gears then for those matters that don't involve child custody, or child custody is just one component of the case. What are some of the things you think through with those clients to determine which issues are worth, quote, like fighting for, meaning taking to court, and those that might be able to be addressed in, one of the venues that you just discussed?
So, to answer that question, a lot of times you have to ask your client what's really important to you, what's worth going to court for, and what's not worth going to court for. The court, when it divorces a party, they enter a monetary award. They can transfer property from one party to the other. And so we go through with them what's really important to you, what's not important to you. And sometimes there's issues that arise, and you have to ask your client, is it really worth the attorney's fees of, writing letters, filing a motion, or going to court to obtain this? Is that the hill you want to die on, so to speak? Sometimes it's not worth the headache, the aggravation, and the attorney's fees. And then sometimes there's things that may not have a monetary value so much, but it's sentimental, or it's an heirloom, something to that effect, that we do, in fact, file and seek relief from the court. The court sits as a court of equity, and the court of equity tries to do things in a fair and balanced way. But equity does not mean equal. It looks at the contribution of each of the parties. It looks at the source of funds. It looks at, several different elements as to how property was obtained. But sometimes in cases, people come in and they're really, really irritated. They're really angry. They have a lot of bitterness. And that's another thing that we have to counsel our clients about is, not taking a scorched earth approach to litigation. I think when you and I were speaking about this in preparation, I talked about, killing the golden goose. I've had cases where, one party was committing adultery, and in the one instance, the wife was so angry that she kept calling the employer and emailing the employer. And, finally her husband was terminated. And, in wife's mind, I'm sure it was justifiably so. But in that instance, when the husband lost his job, he wasn't able to find another job after that. And the long-term effect to that family was that their vehicle was foreclosed, their home was ultimately sold, and the wife ended up filing for bankruptcy. And then ultimately later, a couple of years later, my client had to file for bankruptcy because they just never recovered from the loss of the employment. And had wife had counsel that would have counseled her, not to kill the golden goose, so to speak, she may have preserved his employment. As I tell my client, if you want to make the husband pay, so to speak, you want to seek alimony from him. You want attorney's fees from him. You want, maybe more of the monetary award if he's done something nefarious. And so the way to get the relief is to get it from a judge through the court process, not from, taking matters in your own hands and, retaliating or doing something that's going to adversely affect the other party.
Yeah, those sorts of stories are always really disturbing and concerning, because you do see where without appropriate guidance, clients and parties can really do things that undermine what they're really looking to achieve for themselves and their family. And so maybe with something maybe a little less extreme, we've all had clients who want just their day in court to be able to have their story heard, or maybe to be declared right by a judge, or to have the last word. In your experience, what did those outcomes really end up looking like? Does that ultimately benefit the client?
Well, you're exactly right. Everybody has a story and they want to be heard, and it's important for them to be heard, but to do it in the appropriate way. And yes, I've had success where clients have gone to court and they've, shared with the judge, this is what, my spouse has been doing these last, 12 years or 18 years. And in at least two instances that come to mind right away, the court has given a much larger share of the monetary award to the, I guess for lack of a better term, the more deserving spouse, where the other spouse didn't equally contribute to the marriage, didn't equally contribute to obtaining marital property. In one instance, the spouse was very, very physically abusive and emotionally abusive. In the other instance, there was long-term adultery. And the judges did, in fact, consider that. There's obviously no guarantee, but in those instances, the judges listened. They listened to my client. They listened to the testimony and the evidence we put on. And when the judges entered their verdict, it was, more favorable. It wasn't a 50-50 division. So in those instances, they felt vindicated. They felt heard. But that's not always the case. sometimes it's just important for somebody to be heard and get their story out and to be able to look over the aisle at their spouse and say, this is my story and this is what I've been through. And I guess it's cathartic to do so.
Okay. And so for those cases where it's unavoidable, like you just referenced, where there's really serious abuse or, one party just really won't even engage. Once litigation has started, is the door to another resolution process closed, or how can one use the litigation process to in turn achieve an out-of-court resolution?
Well, you're not foreclosed from going to mediation or negotiating a settlement. And sometimes, and oftentimes, through the discovery process and preparing your client's case for court, you put yourself and your client in a better position to settle, maybe than when they first walked in. And so at some point, the opportunity arises that either you or the other attorney can suggest going to mediation or even negotiating a settlement. And that happens probably more often than not. And I guess the layperson wouldn't be aware, but we often settle cases that were consumed in litigation for quite a while because everything's kind of parsed out and you see the lay of the land. And as experienced attorneys, you know how the court's likely to rule in a lot of instances. So we're able to reach a resolution prior to spending time and money in court and frankly, rolling the dice as to what some judge may or may not grant the parties. And that ultimately benefits the clients in saving them, thousands of dollars of attorney's fees and court time. So that's a win-win for the client as well.
Absolutely. I was just going to say that is definitely my experience too, that even once you start down the track of litigating a case, you often then just have additional information and the parties have a little bit more insight into what going to court is really like, and it can provide a lot of incentive for both sides to come together and see if they can work something out. Well, those are all my questions for you today. I've really enjoyed having this conversation, and hopefully our family law community out there has a little more food for thought as to take, information about what's going on in the courtrooms and utilize that to reach more resolutions outside of court. Thank you.
Well, thank you for your time.
This episode of Brief Encounters was brought to you in part by our sponsor, LawPay. Sign up by November 30th to enjoy 12 months of no monthly fee. Learn more at lawpay.com/DCBar.